Now it's time for the last word with Lawrence O'Donnell. Good evening, Lawrence.
Good evening, Alex. And I learned something today about what we call the Wild West, the old Wild West. And that is that there was way more gun control in the Wild West, in those towns, in all those movies we saw where the guys are walking around carrying guns. It was all illegal. In a lot of those towns, you could never publicly carry a gun. And I have a history professor who's going to join us at the end of the show who revealed all of that to me today. I'm so shocked that those cowboy movies were in some ways inaccurate, apparently.
It's a good reminder to all the originalists who want to, basically rewind time back to the 17 and 1800s that they might not have liked the gun laws that existed back then.
Yeah, and nobody was questioning. No one was saying that's un-American, that's unconstitutional. Everybody just went along with the law as it was.
Irony. Yeah. Deep irony, Lawrence.
I'm
excited for the history lesson.
Those were the days. Thank you, Alex.
Thanks, Lawrence.
Thank you. Well, a federal court of appeals has agreed to hear Manhattan District Attorney Alvin Bragg's appeal of a federal judge's order yesterday, saying that a former assistant district attorney, Mark Pomerantz, who briefly worked for Alvin Bragg, must testify to the House Judiciary Committee in accordance with a subpoena issued by the committee and its chairman, Republican Jim Jordan. We reported on that case here last night. The appeals court has given Alvin Bragg until tomorrow to file his appeals brief, and Jim Jordan's lawyers will have a deadline of the next day, Saturday, for responding to that brief. And that pace indicates that the appeals court could issue a decision on the matter as early as Sunday or Monday, paving the way for possible testimony to that committee as early as next week, or who knows. Federal Special Prosecutor Jack Smith is closing in on another one of Donald Trump's lawyers, Boris Epstein. Boris Epstein may, in fact, be a lawyer in name only when it comes to Donald Trump, because although he is licensed to practice law, he has served primarily as a political advisor to Donald Trump. Jack Smith reportedly scheduled a meeting with Boris Epstein in the special prosecutor's office for today. There isn't any reporting on whether that meeting took place or how long it might have lasted. The New York Times reports it remained unclear what subjects the prosecutors wanted to discuss with Mr. Epstein, but given his expansive ties to Mr. Trump, Mr. Epstein is in a position to provide information in both of the investigations that Mr. Smith is overseeing, one focused on Mr. Trump's efforts to retain power after losing the 2020 election, and the other centered on his handling of classified documents after he left the White House. And the Washington Post reports this. Boris Epstein will still work for Trump and is viewed as one of his most trusted confidants, but he is unlikely to continue to work directly with some of the outside counsel handling the pair of criminal probes into Trump's possible mishandling of classified documents at his Florida home and key aspects of the January 6, 2021 attack probe, according to these people who spoke on the condition of anonymity to describe private deliberations by his legal team. On multiple occasions, other lawyers threatened to quit if they had to continue reporting to Epstein. People familiar with the matter said many of Trump's other lawyers, particularly Christopher Kise, have questioned Epstein's judgment and legal advice, while some other advisors have grown exasperated with Epstein and privately mock him. The people familiar with the matter said. Donald Trump will go on trial in a Manhattan federal court next week in a civil rape and defamation case, but Donald Trump won't go to trial. In a civil case, attendance is optional for plaintiffs and defendants, and Donald Trump's lawyers informed the court that he has decided not to attend the trial of the charges filed against him by E. Jean Carroll, accusing him of raping her in a department store in Manhattan in the 1990s. E. Jean Carroll's lawyers have no objection to Donald Trump not attending the trial because, as with all civil cases, the trial is basically a rerun of the testimony obtained in pretrial depositions, and Donald Trump's video recorded testimony of his deposition in this case will be used in the trial instead of his live testimony on the witness stand. Of course, not attending the trial will spare Donald Trump the kind of New York welcome he got last week when he was forced to return to Lower Manhattan to testify in an under oath deposition for New York Attorney General Letitia James. Leading off our discussion tonight is Barbara McQuaid, former U.S. attorney and law professor at the University of Michigan Law School. She's an MSNBC legal analyst. Also with us, Harry Litman, former U.S. attorney and former deputy assistant attorney general. He is a senior legal affairs columnist for the Los Angeles Times. And Barbara McQuaid, let me begin with you on the question of Boris Epstein's involvement in Jack Smith's investigation at this point. He's one of the people who has some knowledge about both of the cases Jack Smith is investigating.
Yeah, and I think one of the things that you touched on there will matter quite a bit here. If Jack Smith wants his testimony, one question will be whether he was acting as an attorney for Donald Trump such that their communications is protected by attorney-client privilege, or he was just acting as an agent, as a business representative, conducting affairs for Donald Trump in that capacity. And if so, none of those conversations would be subject to the attorney-client privilege. Attorney-client privilege is actually narrowly defined as communications between a lawyer and a client for the purpose of receiving legal advice. And so if he was instead acting simply as his agent and transacting business for him, then that privilege would not apply. It's also interesting that you note that he's taking a step back in his affairs with the Trump team. And I wonder to what extent that is a decision because he sounds like he's just very difficult to work with, or to the extent that he's being isolated, or he's choosing to isolate himself because of any cooperation he might be pursuing. So really interesting dynamics around Boris Epstein. Yeah,
Harry, it's not new reporting that Boris Epstein is considered an incompetent by most people who've been around Donald Trump prior to any of his legal troubles and now. And so it's very difficult for whoever the real professional lawyers are around Donald Trump to be having to deal with somebody like that.
The guy has never tried a case. He's always forcing himself to be around Trump. He does seem to be something of a buffoon. And to Barb's point, he actually came on. His official role was consultant. He tried to alter that, or he did alter it to attorney, perhaps to try to exploit attorney-client privilege. His phone has been seized before, and he possibly has involvement in many different places. It's noteworthy that Smith and they were having a consensual sit-down. You know, somebody like Giuliani or others, Smith would right away drag into the grand jury room. So is he first trying to find out what he could tell them, and maybe, to Barb's point again, looking at potential cooperation?
And Barbara, if an attorney-client privilege condition had to be pierced, we would likely know about that because that would likely have involved some kind of legal process to get through that.
Yeah, I think we would at least have some hints about that, Lawrence. You know, as we've seen before, these motions get filed in court. Typically, if it's a grand jury matter, they're handled under seal. But we know that there's at least a matter that the court is looking at. There will be items that show up on the court's docket. Sometimes there's some good reporting that ferrets out exactly what's going on. But I think we would know that there's at least some issue that's being litigated between him and others. So I don't think there's been any indication that that's occurring. So I don't think we've gotten to that point yet. It's possible it could happen without public knowledge, but I think with the rigor with which these matters are being covered by reporters, I think we would probably know about it.
Harry Litman, looks like the federal appeals court is moving very quickly on Alvin Bragg's appeal of yesterday's order by a Trump-appointed judge saying that Mark Pomerantz does indeed have to testify to the House Judiciary Committee, although Pomerantz, the judge said, could refuse to answer any questions he chose to refuse to answer.
And I think that's probably what's going to happen. Pomerantz has some exposure here, Lawrence. He wrote the book, and he's been talking a lot, and sometimes imprudently. I can see a court finally, eventually ruling, you've got to show up. But that might be an anticlimax because he'll show up. It's clear he doesn't want to testify, and he can shut down most of the questioning, saying, I can't reveal anything confidential about the process. Then Jim Jordan can try to take him to court and launch the whole long process, and I don't think he'll get anywhere. So I think he'll get his spectacle, Jordan will, of having him across the table from him, but I don't think he'll get a lot of information.
Well, and Barbara, we're not sure if we even get the spectacle, because what they've asked for is a closed-door deposition, which, if it doesn't go well for Jim Jordan, and if Pomerantz is told to testify by the appeals court and does not give them any real answers, that's not something Jim Jordan's going to want to put on TV.
Yeah, that's right. I mean, I think a big part of this here is a show. It's an effort to intimidate Alvin Bragg and others who might be so audacious as to file charges against a former president. And so if this turns out not to be the show that Jim Jordan wanted, then perhaps he goes quietly. But I do agree with Harry. I think that if Jordan wants Pomerantz to show up, he's going to have to at least show up. These are the same arguments we were making when the tables were turned, and it was, Trump and his cronies that were being sought to have come testify. You have to at least show up, and then you can assert privilege over specific questions on a question-by-question basis. But that may not be the kind of show that Jim Jordan is looking for. Yeah,
I mean, that was my point last night, Barbara, was that the judge's opinion I found startling in its rhetorical excess, Trumpian-like rhetorical excess, but the actual legal points where she landed seemed perfectly reasonably argued if you just subtract all that crazy rhetoric she had in there. I'm always one who believes let's send the witness in to the committee, including, by the way, Jim Jordan when he was subpoenaed. And if you have objections to questions, just take them up question by question. So that's what we may eventually see here. We don't know. Barbara McQuaid, Harry Litman, thank you both very much for starting off our discussion tonight.
Thanks,
Thank you.
Thanks, Barb.
And coming up, I have a few things to say about the Supreme Court. Chief Justice John Roberts has been invited to testify to the Senate Judiciary Committee about the ethics of the Supreme Court. Everything the Chief Justice said about this subject the last time he had anything to say about it, which was 12 full years ago, has now been proven by Clarence Thomas to be completely wrong. There was once a time when the Supreme Court would not tolerate even the hint of an ethics violation. My discussion about the Supreme Court's history of ethics problems is next, and I have a lot to say about it.
Hi, I'm Tom Llamas, and for me, the news is so much more than a headline. It informs, it inspires, and it still matters. To cover it, you have to be in it. We'll take you to the front lines of the story, where it's actually happening, with NBC News journalists on the ground from all over the world. We cover what you need to know and bring your newsfeed to life. In primetime and streaming live, it's your news playlist. Join me for Top Story, weeknights at 7 Eastern on NBC News Now.
Hi, everyone. It's Nicole Wallace, host of MSNBC's Deadline White House. These days, it seems like every news story out there is about the law, whether it's the multiple investigations into Donald Trump, decisions by the Supreme Court, or the ongoing fallout from the January 6th committee's findings. That is why we have launched Deadline Legal Blog, where legal expert and former prosecutor Jordan Rubin breaks down the legal implications to some of the biggest stories of the day. Read the latest at msnbc.com/deadlineblog.
We have a resignation letter from the Supreme Court. In these circumstances, it seems clear to me that it is not my duty to remain on the court, but rather to resign in the hope that this will enable the court to proceed with its vital work free from extraneous stress. That is the letter that Clarence Thomas should be writing to Chief Justice John Roberts tonight. Indeed, to follow Supreme Court precedent, Clarence Thomas should have written that resignation letter years ago, because he has been in violation of judicial ethics for many years, and we now know he has been in violation of federal law since 2014, when he refused to follow the law requiring disclosure of the sale of real estate that he owned in Georgia to Clarence Thomas's favorite right-wing billionaire, Harlan Crow, who has also showered several $100,000 worth of private jet travel and yacht travel that we know about, along with other perks, on Justice Thomas, without Justice Thomas ever disclosing those gifts. Harlan Crow has directly put money in Clarence Thomas's pocket in as many ways as he could find, including by buying real estate from Clarence Thomas and by contributing $500,000 to a nonprofit organization that then paid Clarence Thomas's wife a salary of $120,000. You can do the math on that. Clarence Thomas's wife's salary was funded out of a pot of gold that included $500,000 from right-wing billionaire Harlan Crow, and Clarence Thomas for years filed disclosure forms in which he said falsely that his wife's income was zero. In these circumstances, it seems clear to me that it is not my duty to remain on the court, but rather to resign in the hope that this will enable the court to proceed with the vital work free from extraneous stress. That was written by Supreme Court Justice Abe Fortas in his 1969 letter of resignation from the Supreme Court because he had subjected the court to not quite 2 weeks of controversy about $20,000 that he had received from a foundation 3 years earlier in his first year on the Supreme Court. The $20,000 was a perfectly legal form of income to a Supreme Court justice at that time, when there were absolutely no laws about justices disclosing anything about their income. Abe Fortas told the story of the $20,000 in his detailed resignation letter. In January 1966, I received a check for $20,000 under the agreement and began my association with the foundation. Later, in June 1966, I reached a decision that the continuing role in the foundation's work, which our agreement contemplated, should be terminated. There were 2 reasons for this decision. My work for the court was much heavier than I had anticipated. I had also learned shortly before informing the foundation of my decision to terminate the agreement that the SEC had referred Mr. Wolfson's file to the Department of Justice for consideration as to criminal prosecution. Mr. Wolfson was the founder of the foundation that paid Abe Fortas $20,000. So Justice Fortas received the $20,000 check 6 months later, decided to end the arrangement, and then later he returned to the foundation the $20,000. That's it. That's the whole story. In his resignation letter, Justice Fortas said, "I have not interceded or taken part in any legal, administrative, or judicial matter affecting Mr. Wolfson or anyone associated with him, and no one ever suggested that Abe Fortas's integrity was ever compromised on any vote that he ever cast on the Supreme Court." That was the entire controversy. He took $20,000, which was perfectly legal to do at the time, from a foundation of someone who later found himself in serious legal trouble, and Abe Fortas immediately backed out of the agreement, returned the $20,000. That's the whole story. And when that story came out in 1969, Democrats and Republicans immediately called on Abe Fortas to resign from the Supreme Court. Now, let me repeat that. Democrats and Republicans called for Abe Fortas to resign from the Supreme Court. Both parties then believed in imposing the same ethical standards of the Supreme Court, no matter which party was involved. And one party had a tremendous amount to gain by Abe Fortas's resignation. Abe Fortas was appointed to the court by Democratic President Lyndon Johnson. And when he resigned, Republican Richard Nixon was president of the United States. And Abe Fortas's resignation enabled Richard Nixon to remake the Supreme Court from a liberal-leaning Supreme Court to a conservative-leaning Supreme Court. The Democrats who called on Abe Fortas to resign from the Supreme Court knew that Republican Richard Nixon would get to replace him, but they still demanded his resignation. This guy was the first Democratic senator to demand Abe Fortas resign from the Supreme Court. He went on to serve as Jimmy Carter's vice president and then the Democratic nominee for president in 1984, who lost 49 states to Ronald Reagan. It never crossed Senator Walter Mondale's mind that Abe Fortas should not resign because there is a Republican president. The Democratic-controlled House of Representatives was threatening to impeach the Supreme Court justice appointed by the Democratic president because of that $20,000 that Abe Fortas received and returned. Abe Fortas did nothing compared to what Clarence Thomas has done. Nothing. In his resignation letter, Abe Fortas said, "There has been no wrongdoing on my part. There has been no default in the performance of my judicial duties in accordance with the high standards of the office I hold." And absolutely no one anywhere offered a shred of evidence to contradict that. Nothing to suggest that Abe Fortas did not perform his judicial duties in accordance with the high standards of the office that he held. Abe Fortas went on to say something that Clarence Thomas, who has been shown to have violated federal law, could never bring himself to say, because Clarence Thomas does not believe what Abe Fortas believed about the Supreme Court. So far as I am concerned, the welfare and maximum effectiveness of the court to perform its critical role in our system of government are factors that are paramount to all others. It is this consideration that prompts my resignation, which I hope, by terminating the public controversy, will permit the court to proceed with its work without the harassment of debate concerning one of its members. Clarence Thomas is prepared to put the Supreme Court and the country through the harassment of unending debate about Clarence Thomas's massive and repeated ethical failures and violations of law and the Supreme Court's general ethical failure. The chairman of the Senate Judiciary Committee, Richard Durbin, wrote a letter of invitation to Chief Justice John Roberts today, inviting him to testify at a public hearing regarding the ethical rules that govern the justices of the Supreme Court and potential reforms to those rules. The last time John Roberts revealed any of his thinking about this subject was in writing 12 years ago. Chief Justice Roberts has been absolutely silent during a period when the ethical standards of the Supreme Court have been publicly questioned more vigorously than at any point in the Supreme Court's history. On the last day of 2011, the Chief Justice issued his annual year-end report on the federal judiciary, and he included a few lines about ethical standards, which may have seemed not unreasonable at the time, but through the lens that investigative reporting has given us on Clarence Thomas now seems downright childish. The Chief Justice wrote, "All members of the court do, in fact, consult the code of conduct in assessing their ethical obligations. In this way, the code plays the same role for the justices as it does for other judges." That is not true. Other federal judges are bound by the code of conduct. The Supreme Court justices are not bound by the code of conduct. So to say that they consult the code of conduct is in every important sense meaningless. Then the Chief Justice went on to say something that we know is absolutely false. Every justice seeks to follow high ethical standards. That is not true. We know beyond a reasonable doubt that Clarence Thomas absolutely does not seek to follow high ethical standards. Clarence Thomas's personal code of conduct appears to be to follow the lowest possible ethical standards that he can get away with. And then Chief Justice Roberts wrote a line that he would not dare try to get away with today. The court has had no reason to adopt the code of conduct as its definitive source of ethical guidance. Clarence Thomas has now given the court every reason to adopt the code of ethics, which the Supreme Court absolutely continues to refuse to adopt. One of Chief Justice Roberts' principal reasons for why the Supreme Court doesn't need any ethical rules whatsoever was this line written in his 2011 report. The justices filed the same financial disclosure reports as other federal judges. Those reports disclose, among other things, the justices' non-governmental income, investments, liabilities, gifts, and reimbursements from third parties. Yes, the justices file financial disclosure reports. And yes, Clarence Thomas files financial disclosure reports that are not true. Justice Thomas refuses to include information that is required by law to be included, like the sale of real estate. To our knowledge, that has never happened before in the history of the Supreme Court financial disclosure reports. Senate Judiciary Committee Chairman Dick Durbin promises Chief Justice Roberts that if he shows up for the hearing, the questioning will be limited to Supreme Court ethics. That's not exactly reassuring for the Chief Justice. In that hearing, it would be very likely that questions about activity of Clarence Thomas's wife would come up. If the senators were being thorough, and there's no guarantee that they would be on this point, they would also ask a few questions about the Chief Justice's wife. Jane Roberts, who is a very high-paid lawyer, works at a firm that describes her as a high-end legal recruiter with 20 years experience as a practicing attorney and law firm talent developer. One of Washington's most insightful and experienced legal recruiters, Jane advises high-profile law firm partners and groups on lateral moves. So, Jane Roberts doesn't work for one law firm. She works for maybe every high-powered law firm in Washington and possibly even the country in finding lawyers for them. And the lawyers in those law firms appear before her husband at the Supreme Court. It is possible lawyers recruited into their jobs by Jane Roberts, for which Jane Roberts was paid a lot of money, appear arguing cases before her husband at the United States Supreme Court. Now, I am sure that Jane Roberts feels the way Abe Fortas felt, and that Chief Justice Roberts feels the way Abe Fortas felt when Abe Fortas said in his resignation letter, "There has been no wrongdoing on my part." Abe Fortas resigned because of the possible appearance of impropriety, not because he actually did anything wrong. Jane Roberts' work invites the appearance of impropriety. But it is because the work is done quietly and invisibly, unlike Ginny Thomas's mad rantings to Donald Trump's White House chief of staff, which have become public thanks to the subpoena power of the January 6th committee. Establishment Washington is untroubled by Jane Roberts deriving income from more law firms than we could ever count. There is a model of propriety for spouses of people who find themselves in positions requiring the highest ethical standards. The leading model, the best one we have ever seen for how to handle this, is the very first man in history to be married to the Vice President of the United States. Attorney Doug Emhoff was a very highly paid, high-powered lawyer in Los Angeles in a huge corporate law firm with offices around the world. He worked primarily on entertainment matters that in no way interacted with the governing decisions of the White House. But not because he was ever going to be in a position to do anything wrong, but purely out of respect for the importance of the clarity of ethical standards, Doug Emhoff resigned from his law firm. He quit. He took a huge pay cut because he didn't want something done by some lawyer he never met in the London office of that law firm to ever suggest some possibility of a conflict of interest with White House policy. And so Doug Emhoff is now Professor Emhoff. He teaches at a law school in Washington, D.C. That's the model. That's the perfect model. Zero possibility of conflict of interest. Zero. The wife of the Chief Justice could do the same thing. Law schools in and around Washington, D.C. would love to have her. But they won't pay as much as the corporate law firms that put money into the Chief Justice's wife's income. Washington is so willing and so hardwired to accept that kind of appearance that no one in Washington has ever been even slightly concerned or questioned what the Chief Justice's wife does for a living. And this is very important. It is very likely, it is my personal belief, certainly, that no member of the Senate Judiciary Committee would raise that question with the Chief Justice if he were to show up for the hearing. And I also want to stress that I personally believe that the Chief Justice, John Roberts, has never been compromised in any way by his wife's work. I think that is the likelihood. Chief Justice Roberts, disagree with him as you might, does appears to me anyway, to be the kind of traditional member of the Supreme Court who would know exactly how to seal himself off ethically from his wife's work. Clarence Thomas, on the other hand, is the single most outrageous public violator of the ethical norms of the Supreme Court that the country has ever seen in our history. Think about how outrageous Clarence Thomas's conduct had to be to get this attention. Clarence Thomas never knew where the line was. The only way for Clarence Thomas to find out where that line was to just keep going, was to just keep pushing the dollar up, 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 the dollar numbers just up, up, and up, and to keep flying on Harlan Crow's private jet and to keep sailing on his yacht until Clarence Thomas found the line and crossed the line. In his resignation letter, Justice Fortas said, "It is my opinion that the public controversy relating to my association with the foundation is likely to continue and adversely affect the work and position of the court, absent my resignation." Abe Fortas resigned from the Supreme Court because he thought the controversy about him would adversely affect the work and position of the court. Clarence Thomas has proven that he is not even slightly concerned about how his ethics violations adversely affect the work and position of the court. 16 of the most reckless Republican House extremists, including Marjorie Taylor Greene and the usual suspects, along with 3 of the most reckless Republican senators, Senator Mike Lee, Senator Rand Paul, Senator J.D. Vance, co-signed a letter to President Biden today saying there are appropriate ways in which the U.S. can support the Ukrainian people, but unlimited arms supplies in support of an endless war is not one of them. Our national interests and those of the Ukrainian people are best served by incentivizing the negotiations that are urgently needed to bring this conflict to a resolution. We strongly urge you to advocate for a negotiated peace between the two sides, bringing this awful conflict to a close. Unrestrained U.S. aid for Ukraine must come to an end. Joining us now is Timothy Snyder, professor of history at Yale University. He is the author of The Road to Unfreedom, Russia, Europe, America. Professor Snyder, what is your response to that letter?
Well, there's a basic logical error, which, I mean, all good Republicans who know about national security immediately grasp, which is that you don't have a choice between war and negotiation. We all want the war to end, but unfortunately, this is a sort of war where the aggressor has to be defeated. If you want peace, there's only going to be peace when one side wins, which means the question is, which side do you support and which side do you want to win? In the case of the signatories of this letter, it's unfortunately clear from other circumstantial evidence, other things that they've said, that their preference is that Russia win. I think it's, the preference of decent people who want the rule of law and democracy is that Ukraine should win. So that's my fundamental response. I mean, the second very important thing is that the premise of this letter is that somehow this is a drain on U.S. national security. It's not. It's a bonanza for U.S. national security. Ukrainian resistance does more for American national security than anything we can do. For literally a penny on our tax dollar, the Ukrainians have drastically reduced the threat of a larger war in Europe. They've also drastically reduced the threat of a conflict in China because they've shown how difficult offensive operations are. We're getting all of this without putting at risk the life of a single American soldier. The letter says that it's the Americans who are paying for this war, but that's just not true. I mean, we pay a bit of money. A lot of that money actually goes to our own arms manufacturers who employ Americans in America. But not a single American life is at risk. It's the Ukrainians who are paying the real price of this war. They're the ones who are defending us, and that really ought to be acknowledged.
I just want to be fair to the letter. It is a well-written staff letter that is not well argued, in my view, based on the points you just raised along with others. But Marjorie Taylor Greene didn't write this thing. It's not something you could just ridicule every line about on the face of it. And that's why it can be very persuasive to people who are not just Republicans out there. It's why I want to hear your response to it. One of the arguments they make is something I've heard outside of Republican circles, saying that we are pushing Russia and China together, and that is a strategic mistake for us.
If we let Russia win, then that's a victory for Chinese power in the world. I mean, there are very few people on either side, Republicans or Democrats, who think it's a good thing for China to become more militarily powerful and more militarily confident. If Russia easily defeats Ukraine, as I think many people in Beijing and Moscow expected, indeed, when Putin went to visit Beijing right before this war started, that is presumably what Putin promised Xi, that this would be a 3-day special military operation. It would all be over, at which point China would be, of course, much more confident and much more powerful. The fundamental result of Ukrainian resistance is that Russia is weaker, and therefore the Chinese-Russian axis, which existed before this war, is weaker. But I'm going to underline this again. The scenario for American-Chinese conflict is a Chinese offensive operation. Ukrainian resistance shows how difficult that is, and therefore it gives us reason to be less afraid of that sort of conflict rather than more.
Professor Timothy Snyder, thank you very much for joining our conversations tonight.
Of course.
Thank you. And coming up, our next guest says gun rights and gun control are not only compatible, they have lived together since the birth of America. Wait till you hear what he has to tell you about what we used to think of as the old Wild West. UCLA professor Adam Winkler joins us next.
There comes a point when a singular event shapes our future, broadens our perspective, and marks a crossroad in our cultural landscape. The Turning Point, an original documentary series from MSNBC Films and executive producer Trevor Noah that explores these watershed moments for the biggest issues of our time and asks how we got here and where we go next. The Turning Point documentary series on MSNBC and streaming on Peacock.
This is Nicole Wallace from MSNBC. Donald Trump became the first ex-president to be arraigned on criminal charges, pleading not guilty to 34 felonies. On MSNBC's new podcast, Prosecuting Donald Trump, legal analysts and veteran prosecutors Andrew Weissman and Mary McCord break down how Alvin Bragg, Fonnie Willis, and Jack Smith might think about building a case when the defendant happens to be an ex-president. Search for Prosecuting Donald Trump wherever you're listening and follow.
If you think that Republican legislatures around the country passing laws allowing people to openly carry handguns and rifles anywhere and everywhere is sending us back to the Old West, you're wrong. Among the many things pioneered in the Old West was gun control. Tombstone had much more restrictive laws on carrying guns in public in the 1880s than it has today, says our next guest, UCLA professor Adam Winkler. Today, you're allowed to carry a gun without a license or permit on Tombstone streets. Back in the 1880s, you weren't. It was common in many Western towns that have gun control. The local law And Tombstone then forced visitors to the town to turn in their guns when they arrived in town to the local sheriff, who would give them a receipt like a coat check. And when they were leaving town, they could get their guns back. Residents of the town were required to keep the guns at home. And no one thought there was anything un-American or unconstitutional about local, strong gun control laws in what we now incorrectly think of, I guess, as the Wild West. Professor Winkler says gun control laws were adopted pretty quickly in those places. Most were adopted by municipal governments exercising self-control and self-determination. In this photo, you can see a main street of a town, and in the middle of the road, that sign, which is very, very difficult to read at the top, very top of it says, carrying firearms strictly prohibited in that town. The statistical records of that era indicate that the towns with strict gun control had lower murder rates than the towns without gun control. Joining us now is Adam Winkler, law professor at the University of California, Los Angeles. He is the author of Gunfight: The Battle Over the Right to Bear Arms in America. Professor Winkler, I have learned so much in a day that I did not know before. You also talk in your book about the founders and their attitude toward gun control. What do we know about that?
Well, we know that the founders did have gun control. They barred large portions of the population from possessing guns, including people who were enslaved, also free blacks, and even white men who opposed the revolution. People who refused to swear an oath of loyalty to the revolution saw their gun rights restricted. And we're not talking about traitors. It turns out lots of people were opposed to the revolution at the time. And the founders also had severe militia laws that required gun owners to appear at public meetings where they and their guns would be registered on state rolls. So they definitely understood that we had to balance gun rights with gun regulation.
You make the point that the towns, as they developed economically, especially the ones that had the highest